Thank you particularly for your work and the work you've done about Virginia and the surveys you've done about criminal practice in Virginia. In light of that, will you comment on a Virginia-specific answer to Doug's question,
Yeah.
how are we doing?
How are we doing in Virginia? Well, we've had many DNA exonerations in Virginia, and a lot of innocent people walked out of our prisons, many more without DNA. A few things have changed in Virginia, but not too many. We've had some of the most noteworthy false confessions in the country out of Virginia, some of the most high-profile false confessions. But it continues to be the case that the vast number of agencies don't require videotaping of interrogations. And there is no model guidance even at the state level for how to do an interrogation right. And when I've looked at interrogation policies at the different agencies, a handful have very good policies, but many of them don't say anything about what happens if you're interrogating someone who's intellectually disabled. What do you do if it's a juvenile, short of letting the parents know, no guidance. On the eyewitness identification front, there has been a statute since 2005 which requires agencies to have some kind of written policy on lineups. Most agencies now do. A few may not be in compliance with the policy, but I doubt many. Problem is that there's also very detailed model guidance on what a good agency should do, some of which is pretty straightforward, like either do it blind or put the pictures in folders so you don't have the officer saying, so was it this guy or this guy? But the surveys have shown that very few agencies are following those best practices, and maybe not out of any particular desire not to follow best practices, but what we're seeing is that it was just agencies that haven't updated any of their practices for many, many years. There are not that many agencies in Virginia that are accredited. On the forensics front, the Department of Forensic Science has done some really important, useful things. They've started doing, for example, at least in some of their fingerprinting cases, the kind of blind verifications where you have someone, you don't have a supervisor just saying, oh yeah, you found a match, oh, I see a match. You have someone look at it independently, which is a really important improvement, a really useful procedure. And the Department of Forensic Science has been open to reopening old cases. Some of you may have read about how they were reopening and retesting with DNA some old cases, going back to when Governor Warner noticed that forensics had been saved in criminal cases, and they retested a number of cases and exonerated individuals that had never come forward to an Innocence Project even, or they'd sort of given up and they were exonerated. And so there have been we have an independent crime lab in Virginia with a separate scientific advisory board, which is a useful thing. And they're considering other changes and other improvements. So there's been more change on that front. Sheriff Harding is here in the room. He and I have pushed for the creation of an Innocence Commission in Virginia. There's no group that is focused on particular in thinking about what model policies and guidance and improvements could be made to prevent wrongful convictions in this state. Other states have done things like that, and other states have passed legislation like I've described to improve lineups and to ensure that confessions are done right. And so the Commonwealth has been a real outlier compared to neighboring states, and it's disappointing. Hopefully some of that will change in the years ahead.
What kind of safeguards can be put into place to prevent the corruption in some police departments, such as we're seeing supposedly in Chicago at the current time? Forensics doesn't help if people are cooking the books. So what can be done in cases like that?
Well, there is, in general, not much transparency around policing. I suppose both of my books are about problems where not enough information was known about what even happens in the cases. So people just weren't even collecting these deals that corporations are entering with the federal prosecutors. And having collected that information, actually prosecutors have found it useful. It's useful for them to see what deals their colleagues are negotiating. Well, the same is often true of police practices. Many police departments don't even make their policies available to the public. Some agencies post them online. They want people to know this is how we This is when our officers can use force. This is when our officers, what they do when they do lineups. There's an amazing lack of accountability and transparency for many police agencies. I was doing a survey recently, just looking at the largest 50 agencies in the country by numbers of sworn officers. What are their use of force policies? Well, a shocking number of them don't make their force policies public. You think that, well, that's a really important policy. You think the public should know when officers are authorized to use deadly force on members of the public. Shouldn't people have a right to see what their guidance is on that subject? Well, plenty of agencies don't think the public has a right to know. And so there's just an amazing lack of democratic accountability, although some departments are much more responsive than others. There's another problem related to wrongful convictions that I haven't talked about, which is criminal discovery. What do police hand over when they gather evidence to the prosecutors? What do prosecutors then hand over to the defense? And in Virginia, it's been a problem. The Virginia Supreme Court, somewhat inexplicably in my view, decided not to adopt some recommendations to change the discovery rules in Virginia. We have some of the stingiest discovery rules in the country, although many agencies have open file policies in Virginia and don't believe in adhering to that stingy rule. They believe that the defense should see the file and see what evidence was gathered in the case. It usually helps for the defense to know how strong a case they have. When it's a strong case, you settle the case more quickly. But it is hard to have accountability in particular cases when evidence isn't typically provided in a forthright way. And we have a Ninth Circuit judge, not a liberal judge, talk about an epidemic of police and prosecutorial misconduct where evidence is concealed, including in high-profile white-collar cases. It often comes out in the corporate cases because high-profile and wealthy defendants have the money to investigate these cases to death, and so they may uncover the prosecutorial misconduct, the documents, the FBI reports that didn't come out. For a regular criminal defendant to learn that something was concealed, if it was concealed, well, it may have been concealed successfully. You have no way of knowing. And so that's another problem across the country. Some states have addressed it, most have not.
But also, in what you were saying there, isn't one of the most basic gaps in the system the insufficiency of the public defender system? That essentially the vastly disproportionate use of the resources on capital cases, just huge percentage of all the money that is spent by criminal defense by people who are not paying for their own defense. It all goes to saving the lives of people who are on trial for, not all of it, but vast.
Well, actually, not a lot of money gets spent in capital cases, for better or for worse.
Well, but I mean in terms of like the Innocence Project and that there are these resources out there that will try to come to the rescue of someone, particularly if they've been sentenced to death, and there's some evidence that they are guilty. And there's really nothing like that for anybody else if you can't pay for it yourself. But then also just through the public defender system, it's in crisis in pretty much almost every place in the country. So the one place that could catch the problem would be having good lawyers defending you against these things. And most people who go into the criminal justice system don't really have very good access to that kind of defense.
No, one thing we've learned both from corporate crime cases and from death penalty cases is that if it's a case where there are actual facts to investigate, you need a team. Having one lawyer who's just good on their feet in the courtroom or who can negotiate with prosecutors is not enough. And the vast majority of cases get negotiated. No one knows fully what the evidence was or could be. In these white-collar cases where you have tens of millions of dollars spent on someone's defense and cases go to trial, millions of pages of documents are reviewed carefully. You have lawyers scouring the earth to figure out exactly what happened, and you have a number of acquittals in these cases. You have the jury deliberating for 8 days and ultimately settling on a misdemeanor in the Blankenship trial in West Virginia. Blankenship hired an incredible team of talented lawyers. Now, in death penalty cases, you also have to have fact investigators because it's understood and it's constitutionally required that the lawyers investigate their own client to be able to say to the court whether this is a person who's mentally disabled or mentally ill. The lawyers are required to investigate the person's background and social history because that's a life and death distinction. Is this the kind of person who suffered abuse, who suffered traumatic brain injury? That's what the sentencing phase at a capital trial is all about. And lawyers, we're not experts on reading mental health reports. It's less expensive to have investigators do that work, talking to family members or witnesses. And frankly, lawyers aren't that good at it usually. And so death penalty cases have to involve a team which includes fact investigators to do that work of investigating the client. Is this a mentally ill, disabled, troubled person? Often they are. Those are the people who often are the people who commit murders are not right in the head. And when you have those teams of lawyers and investigators working on cases, it doesn't look like it used to when you just had a death penalty lawyer who was a good local lawyer who was good usually on his feet. Those lawyers lost all the time. You know, you did, in Virginia, you'd have like in the 90s, death penalty cases, you'd have like a 2-hour sentencing hearing, half a day. They would call in the murderer's mom saying, oh, he was a pretty good boy when he was growing up. No one's perfect, but he was a good boy. And then years later, you'd find out that this lawyer, who often was known to be a good local lawyer, didn't know how to investigate social history. The mom who said he was a good boy had the kids removed into foster care because of constant alcoholism. The kids would never eat. When the social workers visited the house, everyone was defecating on the floor. These are the actual facts of a case that went up to the U.S. Supreme Court, the Terry Williams versus Taylor case. And so, but these days, you know, when you have, you know, across much of Texas, actually, you have a capital defender or trial office, which has, they actually cost less than court-appointed lawyers, but they have investigators on staff, and they usually win. That's why, you know, Texas, which used to be the #1 execution state in this country, there were 3 death sentences last year. It used to be 40, 50, 60 death sentences a year in Texas. But now that you have, you know, not dream team lawyers, not like what a CEO hires, but just an office which can handle some fact investigation, the death penalty has almost disappeared in Texas. No one would have expected that. Having just minimally competent lawyers makes a life or death difference in Texas, a case where the death penalty is extremely popular, you know, across much of the state. Just, you know, a lawyer who can have an investigator or two who understands mental health records, and they can figure out whether this is someone who can be humanized and isn't the worst of the worst. They can make a presentation like that. Now, a lot of other things have been happening in terms of people's thinking about the death penalty and the cost of these cases, but it is remarkable what a small difference in lawyering can make. But then you wonder about, well, how about all the cases, since there are not very many death penalty cases left in this country, how about all the cases which are not death penalty cases? How about other serious criminal cases where you don't get some team? There are a couple of public defenders' offices that have a more sophisticated team-based approach where they have investigators, they have a little bit more in the way of resources, but you can't count those offices on one hand. You know, the public defender services in Washington, D.C., the Bronx defenders in New York, there are a few offices that have managed to cobble together grants and that do a little more than your regular public defender. But otherwise, it looks pretty grim.
Thank you. You referenced, Professor, a few moments ago, and Doug just referenced the Innocence Project here at the University of Virginia, which has had some striking success in achieving, albeit perhaps years belatedly, reversal of wrongful death convictions. Isn't this in and of itself a commentary, if not an indictment of the criminal justice system, that this kind of resource has to be provided basically by students, agreed with the suitable, astute guidance of faculty?
Well, law students are a force to be reckoned with. That's the lesson. We have great students who've done wonderful work on cases, some of which you may have read about. But law students also worked very hard, actually, filing Freedom of Information requests to get me corporate prosecution agreements, which had been sealed. And so several dozen corporate agreements were secured only with the help of law students. Now, in the UK, where I spent some time last year, they have a government agency whose job it is to investigate potential wrongful convictions. And they've reopened hundreds and hundreds and hundreds of cases, more than any, you know, than all the Innocence Projects put together in the US, because it's a government agency and it's their job. And they, you know, sometimes they're slow, and sometimes people complain that they don't get them the relief they wanted in the cases that they thought were good ones. But to have it be the situation where the government views it as their job to investigate these cases, that's a new thing in the U.S. We don't have anything quite like that. We're starting to see these conviction integrity units. The only thing like it in the U.S. is an Innocence Commission in North Carolina, which has a very small staff, but you know, they've reversed cases where for decades the police and prosecutors said, oh, there's nothing to test. And they've sent their investigator to the station, and they find a nice box which has stuff that can be DNA test. And you had two of the most high-profile death row exonerations in U.S. history come out of North Carolina a year ago because of a box like that was supposedly didn't exist. But it was because there was a government agency that had the power to go in and investigate. And our law students don't have that. They don't have subpoena power. They don't have formal investigatory power. Innocence clinics and projects can try to talk to witnesses who are willing to talk to them. They can try to encourage government to test DNA evidence. And these days, prosecutors are very receptive to those requests, but it's not easy from the outside to investigate cases. It makes sense to investigate cases from the inside. But that's not something that as a society we've dedicated resources to for the most part.
Could you clarify for us exactly what happens to the proceeds from these massive sort of no prosecution agreements?
Yeah.
I mean, I know it gets spread across prosecuting agencies, but you're suggesting there's a real conflict of interest there, I think. Could you sort of sort that out for us?
Well, early on, you even saw corporate agreements where there would be sort of community service provisions that were unrelated to the case itself. One of the best known ones was a case where, when Chris Christie was Attorney General, the company agreed as part of the deal to give several $1 million to Seton Hall Law School to endow a chair in legal ethics, which maybe would actually be, I actually think that would be wonderful if these cases all involved giving more money to law schools to endow fancy chairs. I don't understand why Christie's idea didn't take on. And so,
Or public television programs.
Or public television programs, right.
Good destination.
So somehow the Department of Justice thought better of that approach, and they issued some guidance that you shouldn't be doing that. But it really depends. Sometimes the penalties are set aside as restitution to victims, sometimes as forfeiture, which can be given to victims through a more complicated process, but which tends to go to different law enforcement agencies. And what can be troubling about that is you can have J.P. Morgan pay $1.7 billion in forfeiture, but does that forfeiture money go to the agencies that are investigating financial crimes? If it did, then we'd have an incredible SEC that could hire all sorts of investigative lawyers and do much more in the way of enforcement supervision of public companies. But no, you can have that money go to state and local police or agencies that had nothing to do with the particular case. And that often happens. Penalties themselves go to the Treasury. And so if it's not forfeiture or restitution, it tends to go to the Treasury. There's some cases where that isn't the case, but for the most part, you don't have the money going directly to the people who bring these cases. Now, there would be a concern if the fraud section at DOJ was getting a bounty every time it brought a case, right? There'd be a lot of concern that there would be, kind of like you have concerns about civil forfeiture locally, where you worry that police are seizing people's vehicles just to take a bunch of cars. Apparently there was more billions taken in civil forfeiture in this country last year than were taken in burglaries from citizens. So it might not be ideal if prosecutors were sort of keeping a share of the winnings. Still, you have the SEC going to Congress every year saying we can't do the enforcement that we're supposed to be doing, not even remotely, and nothing ever changes. You had hiring freezes for several years after the financial crisis at the Department of Justice, and people are saying, why aren't they investigating these companies responsible for the financial crisis? Well, they had a hiring freeze. And people who are working at these elite fraud units can leave for really high-paid jobs at very good law firms. They're not going to stay for 10, 15 years. You had really talented people leaving, and they couldn't be replaced during a crucial time for the Department of Justice. And so, it would be nice if these prosecutors who are doing enormous public good and bringing cases of incredible social importance had more in the way of resources commensurate with the work that they're doing. We haven't seen that, and obviously you're not going to have the Chamber of Commerce clamoring for more enforcement resources in this country, right? But there could be a shift. There is also there has been more of a shift in recent years towards better sort of financial and fraud enforcement. both in terms of investigative resources at the FBI and the Department of Justice. We're starting to see the pendulum go in the other direction, but it's been slow.
Just as an aside, my son was hired by the state attorney general in New York for his computer skills
Yeah.
for the Love Canal case. It was the first case that they actually computerized all the records. I think there were 150,000 pages of testimony that they had organized. But my real question has to do with the change in law and prosecution that it seems to me has happened over the last 30 or 40 years, and that is that we seem to have more deference toward companies and corporations than we do toward people. It seems to me as though companies and corporations get away with a tremendous amount of illegality that possibly might end up being a fine. Whereas if it's an individual who has committed an illegal act, that person goes to jail.
Well, you can't literally put companies in jail, right? Which is the conceit of my book title, asking a company to pay a fine can do a lot of good if they caused financial damage to people. That really is the best way to punish if it's purely financial misconduct. I talk in the book, though, about the importance, and prosecutors are taking this on. It's ambitious and difficult work to try to structurally reform companies that have a culture of criminal conduct. I mean, when the company is a crime scene, it's a very different kind of crime scene, obviously, where people in the public may have no idea a crime happened. But that's what a fraud is, right? You're fooling someone, it's deceit. The victim may have no idea that they are a victim. And that's very different from a street crime. Some corporate crime cases, obviously, everyone knew that there was a horrible tragedy and explosion in the Gulf, the Big Branch mining disaster in West Virginia. Some corporate crimes are out there in the open. Or a company collapses because they've been misstating their earnings and people can pretty much guess that something serious went on. But other frauds are complex and they may not even come to light unless actually there's an incentive for a whistleblower to come forward. And there has been a focus on trying to incentivize whistleblowers in recent years. Dodd-Frank had some enhanced whistleblower protections and provisions in them. Unless the company self-reports, unless a whistleblower comes forward, you have no idea that anything happened. And that's actually a very good change that the DOJ included in their latest set of changes to their corporate guidelines, which a lot of people haven't focused on. They want to give strong incentives to companies to self-report violations, because otherwise we may never know that a crime happened. And in the past, you sometimes had companies that absolutely came forward and said, we committed a crime, no one knows it, but we did, and we want to make it right. And you'd have that company sort of pay the same fine as a company that was turned in by someone else and wasn't cooperative and was obstructing the investigation. Those two companies should be treated very differently. Now, obviously, if someone comes forward to the police and says, you know what, I'm self-reporting, I murdered my neighbors. You wouldn't say, oh, okay, well, we want to give you full credit, deferred prosecution. I mean, if the crime is serious enough, you shouldn't escape clean. But if you're a corporation that isn't going to jail anyway, you really want to incentivize, especially if they say, we're coming clean, we're self-reporting, and we'll tell you who did it and how it happened. That's significant, and that is a big change that the Department of Justice says they're going to focus on that. We'll see how they actually do it in practice.
Thank you very much.